My name is Denise Rotheimer. My daughter Jasmine was raped at the age of 11 years old in 2001. I learned of the incident in 2002, and at which time my daughter and I went to the police, filed a report. Subsequently, the prosecutor took the case and the defendant was convicted and sentenced in 2003 at a 7.5-year prison sentencing term. Throughout the whole course of the criminal prosecution, my daughter and I were not kept informed of the sentencing of a negotiated plea deal that occurred. I learned on the morning of the sentencing by the defendant's attorney that the state negotiated a plea deal for the minimum 6-year sentence. I located the prosecutor handling the case and asked why she requested a 6-year minimum sentence. She told me I was not a lawyer, that she did not have to explain the law to me. I told her I am the mother. I went to the court and approached the bailiff, asked the bailiff if he could let the judge know I disagreed with the minimum 6-year prison sentence. After the prosecutor made her factual basis, the judge was approached by the bailiff, and at which time informed of my earlier request. The judge called me to the bench. I was asked by the judge if I disagreed with the sentence, and I explained why. After the judge heard the facts of the case that I disclosed, which the prosecutor omitted from her factual basis, she instructed the prosecutor to go up a couple years because she would not accept the minimum based on the facts I disclosed. After the offender received his 7.5-year prison term, I went to a private attorney to see if I could sue the prosecutor because she actually made it as though my daughter was the perpetrator in the case in order to pursue a minimum sentencing of 6 years. That's defamation. And the private attorney I went to faxed me the Crime Victim Rights Act. It's a state statute. In that state statute, I read the bottom, which is the scope of the act. It states that as a crime victim, we have no right to a cause of action, meaning there is no remedy for us. Offenders, you need to understand, have enforceable rights. If their rights are violated, they could file a civil suit. However, victims, we don't have that right. In fact, we are denied that very right. Therefore, I pursued a federal case in federal court against the state of Illinois because the state of Illinois General Assembly enacted the law that is currently unenforceable, that I'm trying to amend, as well as the state's attorney in the case against my daughter's rapist and the prosecutor who actually handled the case and violated our rights. However, when you go through the criminal justice system, you are going through it as a victim, someone who has no enforceable rights. You may never even know you have rights, as in my case and with my child. And after everything is said and done, there's nothing you can do when those rights are violated. I received a letter today from Lisa Madigan's office in response to the federal case that I filed this year, January 12, 2011. And in the response from the Attorney General's office, they are requesting a motion to dismiss the case. The motion consists of language that I will quote. Even if this court were to consider the merits of any statutory challenge, it is clear that the statutes in question do not deprive plaintiffs of life, liberty, or property without due process of law, nor do they deny plaintiffs the equal protection of the laws. Plaintiffs have not identified, nor are there any such federally protected rights that exist in the context of a victim's rights in a criminal proceeding. As such, any claim that the statutes in question are in violation of the 14th Amendment must fail. I'd like to bring your attention to a letter dated April 15, 2004, which Lisa Madigan, Illinois Attorney General, signed, and I will quote from that letter. All materials that I am quoting will be displayed for your review in its entirety at www.momsv.org. That stands for Mothers on a Mission to Stop Violence. The April 15, 2004 letter states, despite the best intentions of our laws, too often crime victims are still denied basic rights to fair treatment and due process that should be the birthright of every citizen who seeks justice through our courts. In the words of Lisa Madigan, Illinois Attorney General, states, too often crime victims are denied basic rights to fair treatment and due process. Again, let me remind you of the statement made by the attorney representing the state of Illinois, Lisa Madigan's office, on behalf of the suit I am filing to make victims' rights enforceable. And it states, and again I quote, it is clear that the statutes in question do not deprive plaintiffs of life, liberty, or property without due process of law. The 14th Amendment was added in the U.S. Constitution to allow for state action. When our rights are violated at the state level, we can bring a cause of action against the state for a violation of our due process of law and equal protection under the law. I've already made the case on the due process issue, meaning victims have no cause of action for damages under the Crime Victim Rights Act, which is what I am trying to get a court to hear this case in order to make that language unconstitutional. When your rights are violated, like the accused or defendants, they do have a cause of action when their rights are violated. The second half of that is the equal protection. Illinois Constitution allows us under Article 1, Section 12, remedy and justice. We have a right to hold wrongdoers liable when our rights are violated. However, because of the language I stated from the Crime Victim Rights Act, where we are not allowed a cause of action, we do not have access to our constitutional right to remedy and justice. I'd like to point out from a Criminal Justice Information Authority report, Mr. Spencer stated the committee met on January 30th, 2001. And in this meeting, Mr. Peeland, and again, a copy of this will be posted on the website, www.momsv.org, for your review in its entirety. And I quote, Mr. Peeland stated that victims of violent crime ought to be given high priority and appropriately addressed in our state plan. He expressed concern that while we do need to do more for victims, the plan's objective to develop a system of recourse for victims who feel their rights have been violated is not consistent with where we really are in this process. End quote. And in this, the Criminal Justice Information Authority furthermore states, Mr. Peeland said he thinks that we are jumping ahead of ourselves in terms of our ability to provide recourse when victims don't know what their rights are and they aren't being given services that they ought to be provided. Initially, I stated that my daughter and I, in 2002-2003, went through the criminal justice system without any knowledge or information of our rights, and it is a right for us to be informed. Because these rights are unenforceable, you may go through the system without any knowledge, and if you do, and the case is closed, you will again have no recourse to hold your wrongdoers liable. This is an injustice. This is a violation of our 14th Amendment, federally protected due process of law and equal protection under the law rights. Join in the cause. Visit www.momsv.org and read all the information for yourself. If you're interested, you can attend the hearing for the motion that the state of Illinois Lisa Madigan, is bringing before the judge to dismiss the case on August 17, 2011 at 9:30 a.m. I will have all that information posted. That's the Dirksen Federal Building in Chicago on Dearborn Street. And my phone number is 847-406-8566. Thank you for your time.
Mothers on a Mission to Stop Violence is dedicated to justice and the protection of children. The mission of Moms V is to raise awareness and provide a resource for victims and survivors to share their testimonies and reach a nationwide audience to take political action in an effort to protect and enforce state laws and our constitutional right to a fair legal system. Please stand up and join us. Visit www.momsv.org and check the calendar for upcoming events.